Thanks for being here tonight, everyone. I'm Amy Stern. I'm a lawyer at Rubin, Glickman, Steinberg Gifford in Lansdale. We are on Broad Street. I've been an attorney there for over 23 years. And I handle wills and estate planning as well as family law. So tonight we're going to talk a little bit about estate planning. So there's 3 areas of estate planning I wanted to talk about tonight: wills, powers of attorney, and then planning, and what you'd like to have done with your assets when you're gone. So these are the 3 areas we're going to talk about tonight. As Sue had said, powers of attorney, a living will, those are all very important. We're going to get to that too. With regard to wills, there's many things that we want to consider when doing your will, when doing your estate planning. These are the main factors that we ask that you think about when you're doing your estate planning. What you want to do with your assets, who you want to receive your assets, how they are going to receive them, because it's not like they just automatically get them through a trust, a custodial account. So there's some different examples, different ways that they can receive trusts or they can receive assets, as well as tax considerations. And you may be aware that the laws changed in 2019. There is no federal estate tax unless you make over $11.4 million individually or $22.8 million as a couple. However, there is Pennsylvania state inheritance tax, 0 between spouses. However, 4.5% children, grandchildren, step-parents or stepchildren or parents, and 12% if you're leaving anything to siblings, 15% anybody else, so friends and other relations, 15% Pennsylvania state tax. What is a will? A lot of people say, can I just write it down on a napkin? Well, a will must be, under Pennsylvania law, a will must be in writing, signed by the testator. If it's not notarized, you should at least have it witnessed. A will is a document that clearly states what is to be done with your assets, who the executor is, who the trustee is. You can name things like a guardian of minor children if you have minor children, and like we talked about, taxes, how their taxes are going to be paid. Language in a will. The executor. The executor is the person who's going to administer your estate, the person who's going to make sure that your money and your assets go where you want them to go. The executor is the person who's going to come to the attorney's office, and the attorney is going to work with that person and make sure that your children get what they're entitled to, your spouse or your siblings or whoever you want everything to go to gets what they're entitled to, that certain funds go into a trust if they need to be, and they're not given to minors until they reach a certain age. So there's many things that the executor is going to help out to do in an estate matter. Our office gets very involved with helping the executor. We do a lot on behalf of the executor. We make sure the estate bank account is open. We contact all of the asset administrators and gather all the assets into the estate account. We pay inheritance tax returns. We take it to probate. So there's a lot involved, and our office is very involved with the executor in that regard. Beneficiaries are who you're going to leave your assets to. There's issues. Is it a minor? Is it somebody who's responsible or irresponsible with money? Maybe you want to set up a trust. So there's a lot of different issues. There's a lot of things to think about. Specific bequests. So sometimes people want to leave money to a charity. There's a lot of different organizations that people are involved in over their lifetime, their churches, and they sometimes want to leave money to charities. They sometimes want to leave a specific bequest to a person or another organization that maybe they're involved in. And that's something that we also ask people to think about. Per stirpes versus per capita. So this is something that you might come across when you're doing your will. People can leave their assets to their family members per stirpes, which means that it goes down the line. So you leave your assets to your children. Well, if one of your children isn't there, perhaps predeceases you, where does that money go? If you leave it per stirpes, it goes to the grandchildren. A lot of people have a concern about, they come in and they don't want their funds or anything going to their spouse, their children's spouses. A lot of people have that concern for many different reasons. Per stirpes, the money will go to the grandchildren, or it goes down the line. Per capita means that if you have two children and one of them predeceases you, that child's money will go to the other child instead of to the grandchildren. Okay.
So the spouses are out.
Spouses are out, but you can't control what your child does with their money when they receive it. They could give it to their spouse. You really can't control that. But you don't have to leave it to the spouse. Okay, trusts. So there are some different kinds of trusts. Just to give you an approximation, we usually recommend there should be at least $150,000 to $200,000 to have a trust or to open a trust. There's different banks that have trust departments. There's different financial institutions that have good trust departments. And we recommend that you use a financial institution as a trustee. We'll get into that a little bit more in a minute. There's different kinds of trusts, a residuary estate trust. So any property that you don't specifically name, if you're not going to leave anything specific to anyone, everything that you have is going to go into the residuary trust. So if you have $10,000 to your church, the remainder is the residuary trust if you have a trust. Disclaimer trust is something that we recommend in certain circumstances, but this is really only right now for individuals who earn over $11.4 million and have to worry about the federal estate tax. But the federal estate tax, that may change in 2025. This law that it used to be $5.4 million that you could have, it just went up this year to $11.4 million. That sunsets in 2025, so it could go back down again. Right now, the disclaimer trust is really only recommended for people who have over $11.4 million in assets. Special needs trust allows a disabled person to receive income without reducing the eligibility for public assistance programs. And that's something that we also get involved in. Education trusts are another kind of trust that we set up for people who want to make sure their children receive funds for their education, and the rest stays in a trust until they're of age. And education trusts are another kind of trust that we set up for people who want to make sure their children receive funds for their education, and the rest stays in a trust until they're of age. And education trusts are another kind of trust that we set up for people who want to make sure their children receive funds for their education, and the rest stays in a trust until they're of age. And education trusts are another kind of trust that we set up for people who want to make sure their children receive funds for their education, and the rest stays in a trust until they're of age. And education trusts are another kind of trust that we set up for people who want to make sure their children receive funds for their education, and the rest stays in a trust until they're of age. Powers of attorney. There's two powers of attorney that we prepare: financial and medical. These are during your lifetime, and you must be competent to sign a power of attorney. So if you have an elderly family member and they are unable to understand what they're signing and they need to go into nursing care, it's too late. They need to sign their power of attorney before they have dementia or some other medical or mental health issue that does not allow them to sign. So it's during your lifetime. First is the financial power of attorney. Financial power of attorney allows someone to handle your assets, allows your agent to pay your bills if you're unable to do so. If you're in the hospital and you can't pay your bills and you can't get to the bank and you can't make your financial decisions or take care of any banking matters, it allows your agent to do that on your behalf. There's very broad powers under the power of attorney now in Pennsylvania, and we have those all specifically listed in our powers of attorney. So you're naming an agent, usually a family member, somebody who lives in the area you probably want to name, who you trust to take care of these matters if you're unable to do so. The medical health care power of attorney is during your lifetime again if you are unable to consent and make medical decisions on your own behalf. It allows your doctors to speak with your agent, so it waives your HIPAA rights. It allows the individual that you're naming as your agent to make major medical decisions on your behalf. We also do living wills as part of our medical power of attorney if people wish to do so, which, as probably most of you are aware, keeps you from being kept alive on feeding tubes under dire circumstances and that sort of thing. If you have a spouse, it would be your spouse. Sometimes a guardian would have to be named, and that's a very difficult process. if there's family members who disagree on who the guardian should be, somebody's going to have to be named to be your guardian to make those decisions on your behalf. A petition may have to be filed, and then you have to go into court and have a hearing on guardianship. And if people don't agree, it could be a big problem. Cremation, we often have people who want to be cremated more and more, so that should be part of your estate planning if that's something that you want to do. There's traditional cremation, there's cremation with disposition of assets, which means they're given to the family member, and there's organ donation. So just some things to think about, and I think that's it for me.